SJC-12202, Commonwealth v. Richard R. Sanborn.
Thank you.
Thank you. Ms. Lazar-Moore, good morning. Not used to going first, huh?
No, it's a little different. Good morning, Ellen Lazar-Moore for the Commonwealth. This case is before the court on a question reported by the district court, which is whether Chapter 209A authorizes the police to effectuate a motor vehicle stop to serve a civil abuse prevention order. It's the Commonwealth's position that the court should answer this question yes, given both the language of Chapter 209A and the public policies underlying the statute. As the court is aware, the purpose of Chapter 209A is to protect victims from abuse. The statute defines abuse as attempting to cause or causing physical harm, placing another in fear of imminent serious physical harm, or involuntary sexual relations. Excuse me. The statute permits an abuse prevention order to issue only where there has been a judicial finding that a person is suffering from abuse or there is a substantial likelihood of immediate danger of abuse. Section 7 of the statute requires law enforcement officers to serve abuse prevention orders upon defendants and file returns of service promptly. And Section 4 requires that when a temporary order issues, the defendant immediately be notified, in the words of the statute. And I would note here that the order at issue here was an emergency order, and it did provide on page 2 that it must be served on the defendant immediately.
But are you making a distinction between emergency temporary orders and permanent orders?
It's my position that an officer should be able to stop the motor vehicle either way, but I note that because the defendant here made a representation that this was in fact not an emergency order, because I had argued in my brief, I had relied in part upon the language saying that under Section 4, a defendant shall immediately be notified. The order at issue here, which is in the defendant's record appendix at pages 1 and 2, on page 2 says the yellow copy of this order must be served on the defendant immediately.
Now, putting aside whether or not it's authorized under the general language in Section 6
Yes.
about reasonable means, when you argue public policy, should we consider whether or not this could be abused? I mean, here we have, if my memory's right, a situation where a police officer sees the person at a bar room and then pulls them over. Wouldn't it be a case where the police could use this as a means to pull people over when they don't have a reasonable suspicion otherwise?
Can I add to that? In this particular case, you have to question the public policy argument that you're making, because the police officer waited for quite some time before he stopped the car after making observations, he said, that the judge said he didn't see. So it relates to Justice Gaziano's point that this public policy argument that you're making is a pretty slippery slope, and it's problematic.
Well, Your Honor, first, looking at the facts here, it's true the officer was running license plates at a bar. When he ran the license plate of the defendant's car and saw that this plate came back to this defendant, he knew that at his briefing just before he came on his shift that night, he had been told, we have a restraining order here that needs to be served upon Richard Sanborn. He called the other officer on duty and said, hey, can you pick up that restraining order and bring it to me? I'm outside this establishment. I see this guy's car is here. In the interim, I think as they were maybe exchanging the paperwork, the defendant came out of the bar and got in his car and drove away. And then the officer followed him.
But wait,
So
he had the order in hand before Mr. Sanborn entered the car, correct?
No, the testimony wasn't clear. The officer said he couldn't remember whether the second officer had actually given it to him or the defendant had driven it away first, and so driven away first, so the second officer was actually following the first officer. Either way, though, either if he had it in hand, it was when he and the other officer were talking to each other in a parking lot across the street that the defendant came out of the bar and got in his car and drove away. So I don't think there was any suggestion that he was intentionally waiting for the defendant to get in his car so that he could then,
But that's what, I guess the danger that we're trying to discuss with you
yes.
is that were we to authorize this, then that would be another way for a police officer so inclined to effectuate a pretextual stop.
I suppose it could be, Your Honor, and in any case where an officer is authorized to make a stop, there's always the danger that an officer could use that, but I think it would be in a very minimal number of cases where an officer would have an active restraining order that needs to be served, happens to see a defendant in a bar, and then waits. And the officer here, there's no suggestion in the testimony, and the judge didn't find that the officer intentionally waited in the hope of, let's say, catching this defendant driving
Well, the
under the
judge did
influence.
find that the officer was not credible about what he claims to have observed. So it's a perfect example of the
Well-
potential for mischief if we were to agree with your interpretation.
Well, Your Honor, what the judge found was not that, it's not that, well, I wanted to stop, it's not that stopping him to serve the order was a pretext for something improper. The judge found that the officer's testimony that he saw 3 marked lanes violations was not credible, and so a motor vehicle violation was a pretext for serving the order. If he's authorized to serve the order, in other words, if the concern is, well, they'll use the 209A order as a pretext to stop him for some other illegal reason, that is not what the concern is here. And when Your Honor asked, well, he followed him for some period of time, he testified that it was literally maybe a mile. He said within the first half mile, he saw the first marked lanes violation, but obviously that could have been caused by, you know, he reached for something, so he wasn't immediately going to pull him over after 1 marked lanes violation. But then he saw 2 more within the next half mile, and that was when he made the determination to pull him over for the motor vehicle violation. Now, it's true that the judge found he didn't credit that because the officer also testified had he not seen the motor vehicle violation, he would have pulled him over anyway before he crossed town lines or out of the town, so that the officer would have still been within his jurisdiction because he did want to make sure he served the 209A order on him. And so that is where the judge essentially said at the hearing, well, he was going to stop him either way. So,
If I could just clarify one thing to make sure I understand the limits of your position. Your position is not that the standard for the issuance of an emergency 209A restraining order in and of itself would constitute reasonable and articulable suspicion to make a stop.
no, it is not.
Okay.
It is just that the question really comes down to, under the Fourth Amendment, whether stopping this car is reasonable. And when the court is balancing the interests on either side, the governmental interest is very compelling. There has already been a judicial finding that either abuse has happened or there's a substantial likelihood of abuse happening. And that is weighed against a driver's interest in not being stopped. I don't say that that interest is nothing. I know that this court has found that that's an important interest, but I believe that it's just as important as enforcing motor vehicle laws. And this court has found, as recently as Rodriguez, that that is a valid reason to stop a car, even though there is no statutory authorization to stop a car to enforce the motor vehicle laws. But this court noted that in Rodriguez and noted that the purpose of enforcing those laws is important enough that officers are authorized to stop someone when they have reasonable suspicion of a motor vehicle violation.
If reasonableness is to be the touchstone, should there not be some, even if you're correct, some requirement of exigency, of need, that for some reason you can't serve him in person, or you can't deliver it to his home?
I don't believe that there should, Your Honor. I think that given, again, that there's already been a judicial finding that abuse has either happened or there's a substantial likelihood of abuse, that there is a concern not only that the victim be protected, because for all we know, this person is driving to the victim's house to possibly abuse him or her again, or, could be driving around for the next 5 hours.
Well, the problem you have, though, is if that was the concern of the police officer, according to the findings made by the judge, Sergeant Hebert called Morial and asked that the order be brought to him at his location. I'm reading it.
Yes.
The 209A order was brought to Hebert. Subsequently, the defendant exited the bar and got into his vehicle. So the facts that we have for the judge, which we need to respect unless they're clearly erroneous, is that Sergeant Hebert had the 209 order in his hand as the individual was leaving, or before the individual left the bar and went to his car. So if the interest you identify is so important, why should we not expect the officer in those circumstances to walk over to the defendant and say, I've got a 209A order, it's important that it be served, and I'm going to serve you right now?
Your Honor, if you look at the testimony at the hearing, I think it was all happening sort of simultaneously. I don't necessarily say the finding is clearly erroneous, although perhaps it is only in the word subsequent. Based upon the testimony, I don't think the judge could have made a finding that subsequent to the officer having it in his hand, the defendant left the bar. The testimony was definitely that it was all happening sort of at the same time. The officer was waiting in a parking lot across the street when the second officer arrived with it. And it was either, again, as they were communicating and transferring the paper, the officer saw the defendant's car driving out, or even that the officer testified he could not recall if he even had it in his hand. And it's possible, because the second officer did follow them, and after the defendant's car was pulled over, the second officer was the one who actually did the inventory search. So the first officer couldn't recall if he had it in hand at that point or if it was given to him after the stop. So,
Can I ask you whether you, is it your position that the enforcement of a 209A order is equivalent to service of that order?
I think that it's part and parcel of it. I think that when I cite each of these provisions about officers shall use all reasonable means to enforce the order, officers shall, the defendant shall be notified immediately, the service shall be made, the clerk shall transmit it forthwith, returns of service promptly, that when the court is looking at what the statute permits, that this all needs to be looked at together and shows a legislative intention, that service be made promptly, that victims be protected from abuse, and that, again, this all goes to the ultimate question, which is what is reasonable under the Fourth Amendment.
But there are other ways to enforce, right? You can get a criminal warrant, you can obviously arrest if you observe something, or...
Yes.
So
But
why
I don't.
don't we include this as being a way to do that?
Well, I don't think the fact that there are other means to enforce means that it's unreasonable to serve a defendant in this way. Again, this was an emergency order, and I think the court can take judicial notice, but I can also provide the docket that this had been issued that evening after hours through the telephone service under Section 5 at 6:06 p.m. that day. This was an emergency order issued, that the police are aware of, many times tragedies happen when someone has already been served and they violate it, but certainly they want the defendant to know that he's been served, that there's been issued a 209A order. They want the victim to be protected from abuse. The order itself tells the officer, you shall serve the defendant immediately, and then the officer sees the defendant driving away. And what is he to do? Is he supposed to just say, oh, well, catch him some other time, knowing that there has been a judicial finding that this victim has either been abused or there's a substantial likelihood of abuse? So I think in that circumstance, again, when we're looking at the competing interests under the Fourth Amendment and what's reasonable, that there's certainly a compelling governmental interest to protect victims of crime after this judicial finding has been made that outweighs the defendant's interest in not being briefly stopped just to give him the order.
Okay, thank you.
Thank you.
Mr. Schnipper, good morning.
Excuse me, good morning, may it please the court. I'm Merritt Schnipper for Richard Sanborn, and with me is Robert Cassessa, who represents Mr. Sanborn in the district court. I'd simply like to begin by addressing the question of whether this was a temporary order. The order that I've included in my appendix has a place for the court to check if it's issued without notice, which is the standard under Section 4, temporary orders issued without notice. That box is not checked on the form. The language on the back of the form that directs immediate service is a standard sort of stamped language on every form. It doesn't really reflect anything about the circumstances of the issuance of this particular order. So that's simply a record question. You know, when we think about the overall question about whether the statute authorizes the police to pull someone over to serve one of these orders, we need to look at not only the requirement that in most circumstances an order be served, but the other provisions that the statute makes to address situations that have heightened indicia of risk in them. The Section 7, which specifically directs the courts to transmit the orders to the police for service unless otherwise so directed, specifically is preceded by an entire paragraph that has basically kind of a mini dangerousness proceeding that a court is required to undertake every time a plaintiff appears and seeks one of these orders. That includes running any potential 209A defendant's name through the statewide probation registry to determine whether there's a history of domestic or other violence. It requires a warrant search, and it requires, in cases where a warrant exists, for there to be a sort of a subsidiary finding by the judge whether the defendant in this particular case poses an immediate threat of danger to or of substantial harm to the plaintiff. And if that finding is made, then the warrant is issued, the police are directed to execute that arrest warrant immediately. Also, anytime someone shows up at a court seeking one of these civil orders, they're required by statute Section 3 to be given information prepared by the district attorney's office about how they can proceed on the basis of the same incident that is motivating this civil complaint to seek a criminal complaint. And of course, any judge hearing, anytime a criminal complaint is taken out, you know, a judge can determine at that point that an arrest warrant needs to be issued based on the exact same incident that motivated the issuance of the civil order, if that's an appropriate circumstance. But as I point out in my brief, the legislature has said that in cases where, you know, criminal complaints or indictments issue, the preference, even in those cases where there's been a finding of probable cause that a crime has been committed, the preference is still for criminal summons and delivery through the ordinary methods of service unless it's believed that a defendant won't appear for a court hearing. So the legislature has indicated that service, whether it's a criminal process or civil process, should be by the default mechanisms that are non-confrontational and don't pose the risks to constitutional rights that pulling someone over to serve a civil order present. And my sister suggests that we're basically engaged in a balancing analysis where we look at the government's interest in protecting people against domestic violence and the interest in a person to not being pulled over in their car. But in Rodriguez, this court specifically said we're not just out here to balance all the time. What makes pulling someone over on the grounds of a civil violation justified in the context of a motor vehicle violation is that the pullover and the civil violation relates directly to the operation of a motor vehicle on the roads and the safety of the driver and everybody else around them. That's not in play here. Now, of course, you know, there is a substantial interest in protecting people against domestic violence. There's also a substantial interest in ensuring that people, and particularly defendants in these cases, are protected by their due process rights. And the statute itself, of course, lays out a very significant mechanism to have a judicial oversight of those subset of occasions when a defendant may need to be immediately apprehended.
Let's assume it is a temporary order that record issue resolves, or take it as a hypothetical. So the police can pull somebody over for a broken taillight. That would be constitutional justification. If there's a temporary order out there and the police know about it, and they see somebody driving away in the car, I guess I'd ask you, what's the police officer to do in that situation if there's not constitutional justification where the order needs to be served immediately?
Well, if there's not, I maintain my position that there's not a constitutional justification for an auto stop to even serve a temporary order. Obviously, the issuance of a temporary order under the statute does carry with it a more significant sense of urgency. I would say, I would note that criminal summons, and the only people who can serve these orders are people authorized to serve criminal summons, which is a practical matter, are, the sheriff and police officers. They are free to serve the orders wherever they wish. Now, my sister says that the officer planned to stop Mr. Sanborn before he left the jurisdiction to serve the order. The officer is empowered to serve that order anywhere in the Commonwealth by virtue of the statute. So it's not as though we need to stop someone at the town line in order to make sure they get served. But it's very interesting to note that the service provisions for criminal process are actually in some ways more lax than the service provisions for civil process, because they envision either serving someone in hand, appearing at their house and leaving it with some person of suitable age, not even the defendant, him or herself, or actually you can just mail an attested copy for purposes of criminal summons. You can't even do that without prior judicial authorization in the case of civil summons.
So on both ends of this case, the police officer, well, let's go to the back end first. The police officer could have followed this person, your client, home, waited for him to get out of the vehicle, and served him,
He certainly could have.
wherever he lived.
Sure.
Okay. On the front end of it, the police officer could have served him when he got out of the bar before he got to the car or get into the vehicle, right?
That's correct.
Could he detain him while the 209A came in from the other police officer?
I don't think he could seize him, and I don't think you can seize a person.
Hey, wait a minute, we've got an order for you.
I mean, I think it would be a means of common courtesy for a person to say, I don't mind hanging around for a moment, but you can't seize them. You can't use official power to detain them for that purpose. I mean, I analogize it to the consensual encounter jurisprudence in my brief, where any officer can approach someone on the street and say, hey, I'd like to speak with you for a minute, and any citizen can say, I'd prefer not to, and keep walking. That includes a person with civil process in their hand. That's why we have leaving at the abode and mailing as other acceptable mechanisms of service. But you and both Justice Hines brought up the question of pretext, and it's difficult to imagine a more pretextual situation than the one presented by this case. And I would say, as a person who's done a number of criminal cases in my career, you don't usually see a district court judge saying, I don't believe a police officer when he says somebody committed 3 marked lanes violations. So, what was happening here was a pretext for a DUI stop. We exist in a legal landscape where we follow the authorization rule, and we say there's any legitimate basis for a police to pull somebody over, we're not going to question why they really did it. That's established law at the moment, but I think a subsidiary proposition of that is that we need to be very careful about expanding further the bases on which police can make these stops, because if it's just over to the question of an officer's discretion about whether someone should be pulled over to serve a 209A order, or maybe I should just mail it to their home as I'm authorized to do under the statute, you're really telling a police officer, here's yet another card in your deck if you want to just pull somebody over and see what's going on. And if they just happen to be leaving a bar at 1:15 in the morning, there may be an ulterior motive that I don't think the court should disregard, especially because we're into the realm of constitutional protections here. And unlike Rodriguez, where, there's a safety relationship between service of a 209A order and sort of the underlying public policy protections for people, but it's not the same as the safety relationship between an auto stop for a broken taillight and an auto stop, because the person is theoretically at least endangering people on the road by not having a functional vehicle. If you're not endangering others on the road by having a 209A order out for you, and you're not in a situation where the person who sought this order has either sought a criminal complaint or has sought, that there's been some sort of finding of a warrant out. I mean, the fact that he was out to serve a regular 209A order means that there had been a database search and that there was no warrant out and there had been no dangerousness finding made here. So to simply say that These orders are not the hardest things in the world to get, and they serve an important need. But if we're simply going to say that once they're issued, and they're issued without any opportunity to be heard on the defendant's part, that now there's license out there to pull the person over and detain them, in this case, end up searching them and arresting them for a crime, we're simply opening really yet another door to significant police misconduct, frankly.
Let me go back to your so-called dangerousness finding. Certainly, if they go back and say he has a warrant, then of course they can stop him on the warrant. If they go back and say he has prior 209A orders now expired, does that change anything?
I don't think it does, because Section 3 specifically says that the existence of an order is not evidence of an incident of abuse.
Okay, so by dangerousness, you mean essentially it shows that they have a warrant, not that they appear to be more dangerous
Well, no,
than the
if a
average.
warrant exists, then the judge is required to make a separate finding on the first paragraph of Section 7.
But in
about whether there's a-
in the absence of a warrant, they don't have the authority to stop in your world, I mean, in your view.
In my view, they don't, unless, of course, the same incident that's formed the basis of this complaint, the civil complaint, has formed the basis of a criminal complaint, and the judge has authorized arrest process rather than summons for that.
So the
criminal
judge could
complaint.
say, if the evidence was that he struck me, the judge could issue an arrest warrant for assault and battery.
That's certainly correct.
Okay. Now, what do we do in a world in which people may no longer have a home? That is, boyfriend strikes or threatens girlfriend. They're living together. He leaves. No one knows where he's going. No one knows if he's going to be living in his car. Is there any exigency exception to your view?
Well, let me take first the question of what happens when somebody doesn't have a home as a result of one of these orders, and then the exigency question. So if the idea is that by a person appearing ex parte at a court proceeding and swearing out a complaint against someone, and the fact that or these incidents surrounding that has deprived someone of the right to live in their home now means, in addition to the fact that they're forced to sleep in their car, they're going to be pulled over by the police, I think we have really a serious imbalance of fairness, basic fairness issues there. In terms of the exigency, the exigency jurisprudence that this court has to do with the idea that some immediate police intervention is needed to head off harm that justifies foregoing constitutional protections. But in this particular case, the statute itself creates a subset of those, looks at that subset of the cases and says, in particular cases where a crime has already been committed or a prior crime has been unresolved and there's a finding of dangerousness, that's the sort of exigency, but that's not an exigency in constitutional terms because it's a statutory authorization that has to do with the finding that a person is already probable cause to believe they've committed a crime. So in the constitutional exigency sense, no, I mean, the swearing out of one of these orders doesn't create an exigency. And even if you have a situation where they're having trouble, first of all, obviously if he's living in his car and he's driving his car, the statewide service of process law allows the officer to follow them. I mean, if it's really so important, we say an officer can't be expected to follow someone endlessly as they spend more hours in their car than they do at home. But, the bottom line is the man was leaving a bar at 1:30 in the morning and he's probably not going that far wherever he's going. So
I'm not saying this would fall into that, but I am concerned about the scenario I give is not that uncommon a scenario of somebody
Fortunately not, that's true.
walks out and they don't know where he's going to go, and they may even know that she's called the police and he may not be coming home, but they don't know where he's going to be, and it's not that easy to serve. That's the concern I have.
No, it isn't that easy to serve, and that may be something the legislature needs to address. But it's certainly within the existing law, an officer can follow a person who's spotted in their car until they stop and serve them with the order. So it's not as though it's impossible to do, but in this rare subset of circumstances, that may be the most appropriate procedure.
So the portion of the statute that says that the police officer shall serve the order immediately, you're saying that statute is unconstitutional in the context of somebody who needs to be served being in his or her car.
The subset, the part of the statute that talks about the temporary orders.
Right.
I'm saying it's unconstitutional if it's interpreted as authorizing an auto stop.
Well, it says.
Says serve immediately.
It says serve immediately.
Right.
So I'm not saying that you're wrong, but when you say that the police cannot pull the person over and serve it immediately, you are saying that that portion of the statute in this context is unconstitutional.
If it were to be interpreted to authorize an auto stop, yes, and I would urge the court to, there's a preference for obviously interpreting statutes so as to be constitutional, and you can look at the other statutes that address service of process, both civil and criminal, and see that there are a variety of mechanisms for service. Now, immediate service, I would suggest to the court, would just simply mean, with all due haste, undertake the standard methods of service, rather than, as we know, civil and criminal service can be kind of a lengthy process. They can sit around until, for instance, in this case, there was a nightly briefing, and they said, yeah, we got an order around here, it needs to be served. They didn't say, job one on our task list tonight is to find Mr. Sanborn and serve him with an order. They said, an officer said, well, I was running some plates at a bar, his name came up, and I remember he had an order out. So I think you can certainly send someone out and make that their top priority to get out there and serve them, and that is immediate in the sense of the statute, without saying that we're going to encroach on these constitutional protections to do so.
So unconstitutional, even if we were to say that there must also be a showing of compelling necessity to stop the car to serve?
I say so because the compelling necessity is based on a civil order, and it doesn't have any bearing to motor vehicle safety and the safety of the highways itself.
Okay, thank you.
Thank you very much.